Okay, Ava Tucker. You can unmute, please.
Hello.
Okay, good afternoon. We're on the record in the matter of Jefferson Capital Systems versus Ava Tucker. The file number is 17-00288 GCE. Ms. Tucker, you are proceeding without counsel, is that correct?
I'm sorry, I didn't hear you.
You're proceeding without an attorney, is that correct?
Yes, ma'am.
Okay, today was the date that was set for a hearing for an objection to income tax garnishment that you filed. The plaintiff's attorney has not appeared, but they did file a response to the objection. Did you get a copy of that response?
I did.
Okay, and so it says a judgment was entered against the defendant on June 1st, 2017 in the amount of $718. The current balance being $1,115.44. That a writ of garnishment was issued by the court for the defendant's taxes. The defendant has filed an objection stating that the judgment has been paid. The defendant provides no evidence to substantiate her claim. So do you have any evidence, ma'am, to substantiate the claim that your balance of the judgment was paid?
Yes, I do have it. Actually, I have all three of my credit reports. And once I received the first letter from them, they said that I owed 54A District Court. So I came here on the 30th of March and I talked to Miss Marquita and she sat down with me and she called Jefferson Capital and she explained to them that I don't owe anything. And then they switched it up and said that I owe Fingerhut that amount. So I called Fingerhut and they said, Miss Tucker, you don't owe us anything. You you opened an account with us on 9/21/2010 and it was paid off February 2014. And the lady at Fingerhut, Miss Grace, she told me, she said Jefferson Capital bought my account from them December 30th, 2015. And I asked them, why did they sell my account to them when I don't owe them anything? And she said, she said, I don't understand that either, but you have to talk to someone at Jefferson Capital. So I called there and I talked to this guy, Chris Frank, and Chris Frank, and he told me if I can get a satisfaction of judgment to send to them and they would release my check. And he said, good luck on getting it because it have to come from us and we're not going to give you anything. So hopefully we don't take your next check. So Marquita asked him, what is this really about? And he said that she owed Fingerhut $1,114.26. And he was told that I don't owe Fingerhut anything, but I do have the proof, the paperwork here. I have all three of my credit reports showing that I don't owe any of them.
Okay, ma'am, we need to see the proof. I do have some concerns with portions of your statement because Ms. Marquita is the manager for the criminal department. This is a civil matter.
Yes.
And so it would be problematic if she's calling creditors on your behalf, trying to understand why you have a judgment. That would not be something she would do.
She did that for me, and she called downstairs to the civil court people. I don't remember the lady's name, but she told me that this is not what she normally do. But since nobody was up here to help me, that's why she said that she took the time out to call these people for me. But she normally don't do that. That's, she said that to me, that she don't normally do that. And for me to go downstairs to get the paperwork to file.
Okay, you need to bring us proof that you've paid this judgment or the judgment's been satisfied.
Okay, I do have it here.
Are you in the building, ma'am?
Yes, I am. I'm across
Okay,
from,
we were not aware. You can come to the courtroom, actually. I didn't know you were in the building.
okay.
Thank you.
I'll come to the courtroom now.
Yes, please.
Okay.
I know Marquita's not here.
Oops. Yes, I did. Do I stand here or here? Right here? Okay. Okay, thank you. Hi. Oh, okay.
So we don't get. Yeah, you just press N and you're good. Okay,
Okay.
you can just or pass him the paperwork that you have that shows that the judgment's been paid.
That's from equal fact. Just explain to me, my credit report. I have all three of them. What is this one? This one. And it's highlighted in pink. Yeah, equal facts TransUnion.
Okay, I'm not seeing where it says it's been paid though, man. Did you pay this?
I did.
Okay, when did you pay it?
I paid Finger Hut off on, the account was open February 2010, and I paid it off on, September, it was open September 10th, 2010, and I paid it off February 2014.
Okay, are these just copies of your credit report? Is that what these are?
Yes, I
Okay, I
called
can
in
see it
for,
says paid and closed on here. And then I see this, which is a screenshot from,
equal facts.
this is for Web Bank Finger Huts.
Yeah, that's what that first they said that I owe 54 A district court that amount of money. And then
Okay, but-
Marquita said that.
So this is saying that the plaintiff is Jefferson Capital. The name of the party that's suing you for the judgment is Jefferson Capital. But I'm trying to see where it says here that this is the same account. All I see is what you printed out, which is for Web Bank Finger Hut.
Yeah, that's who they said that I owe the money to.
I don't know who they is.
Oh, I'm sorry, Jefferson Capital says that they're collecting money from, Finger Hut, and I don't owe Finger Hut anything.
Okay.
But at first they said they was collecting money for 54A District Court. That's what made me come down here.
Jefferson Capital said that?
And they said that to Miss Marquita too, when she was on the phone with me. Well, while we were on the phone with them.
So I'm gonna give you that paperwork back because this paperwork here doesn't help me a lot. Okay, this does say Finger Hut here.
Okay.
This paperwork does say Finger Hut Web Bank. Paid and closed. You can take a copy of this and I'm gonna grant your request.
Okay.
No, just give me the first page and then you can take a copy of that. Make your objection request in order that the funds be released to you, okay?
Okay, thank you so much. Thank you.
Highlight mine, the way you highlighted yours, so I can make sure. Those Finger Huts.
Oh, okay.
Paid and closed. Okay, thank you. Okay, ma'am, you're all set.
Okay, thank you.
Thank you.
Have a wonderful day.
Same to you.
Shut up.
Mr. Cox?
Yes.
Okay, You met already with Mr. McLean, correct?
Yes, met with both Mr. McLean and Mr. McEwen.
Okay. Mr. McLean first.
Ready on both cases.
Okay, we're on the record in the matter that of Edwards Sparrow Hospital versus Devin McLean. File number 21-02733 GCE. Council appearance.
Yeah, good afternoon, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
Okay, Mr. McLean, are you representing yourself, sir?
Yes, ma'am.
Okay. Mr. McLean, today was the date set for both a motion to set aside default judgment. There was also an objection filed for your garnishments. It says here that you are requesting the judge to set aside the judgment because the plaintiff did not send the claim to the VA.
Yes.
Okay, I'm not sure what the word after that says in your handwriting. It says as something after previous conversation, as well as the previous court date. I am disabled vet and cannot. I believe that says afford the bill, which is to be taken care of by the Department of Veteran Affairs. So let's see here. You did appear in December, and your statement is that the plaintiff did not send the claim to the VA, you said?
Yes, Your Honor. They haven't received the claim yet since the first court appearance.
Okay, Mr. Cox, I do have a note that this was going to be resubmitted to the VA, but my understanding was not that you would be submitting them. Did your office or someone from your plaintiff's office submit the claim to the VA?
Yeah, Judge, so as I explained to Mr. McLean, defendant got the judgment set aside in December. And then I emailed my client relative to the what Mr. McLean described at that hearing in December. And I got a response from the Sparrow that indicated that the claim was beyond the limitation period and being denied for filing limits. And so I told them that, they should try anyway. I don't know the status of that. Mr. McLean's indicated in February that the VA was reaching out to Sparrow, but I'm not aware of that because I'm not technically in that loop. I do know that when the case was put back on the tracks, that was that the judgment was reinstated or set aside, the case was reinstated. The matter was set for a pretrial conference on February 9th. And that which time I appeared and Mr. McLean did not. That's the result. That's why the judgment was entered a second time. And technically, currently, there is a garnishment against his wages outstanding. But as it pertains, and we did speak with this about this at length, I gave him my email address. I told him he's more than welcome to forward to me any communications that he's had with the VA and to see if there's some way I can help bridge this gap or to see if there's some way. I don't have a definitive statement as to the status of any billings, but my understanding from a response I got from Sparrow was that this bill was from 2019 and was being denied for filing limits. But I told Mr. McLean too that I would continue to have him try and get with the VA to see what can be done and to include me on any messages perhaps that are going to Sparrow so that I can try to understand what's happening.
Okay, thank you for that explanation. Mr. McLean, why didn't you appear in February?
I didn't receive a notice, Your Honor.
We gave you the date the last time you were here.
Oh, well, I guess I just forgot, Your Honor. Honest mistake.
What's your address?
826 Kaywood Street, Lansing, Michigan.
Yeah,
Or
I have here, your notice to appear was mailed on December 21st, 2021, which is the same date we had the last hearing. But again, that being the second time you've not appeared for court on this, so you're requesting the court to set aside, stating that you didn't get notice. I'll grant your request, sir. It's possible there could have been something with the mail. I don't know. We have the exact address that you put on your motion. The concern though I have now though is what steps are you planning to take to make sure that the VA gets involved and that you're following up? Because you can't just leave it to Mr. Cox and expect him to follow up to make sure your bills get paid, because what's gonna happen is they're gonna still pursue you for the money if the VA doesn't pay it. So you are the one who has the benefit and the contact with the VA. You're gonna wanna be the one to make communication and make sure they're following up and you're forwarding any communications to Mr. Cox, so that to the extent that this is a bill that they would cover, that they would make due on that. If Mr. Cox's client would happily take the money from the VA versus trying to get the money from you whenever they can. The VA has the money. So if they're gonna pay it, then Mr. Cox wants that to happen for his sake and your sake. So, but the issue is you're gonna need to have to get involved a little bit more and appear for court.
okay, I'm sorry about my apologies for missing the court date, the first one. But I spoke with the VA and I got the address and everything about, and then the date that they requested it, the paperwork, the bill from Sparrow, but they never sent it over. So I mean, Sparrow's not sending the paperwork over for them to even look at it and review it.
Okay, so do you have the, oh, okay. You gonna say something, Mr. Cox?
Yeah, Judge, I was just telling Mr. McLean that he should forward to my attention anything he got from the VA and all the information that he's describing with regards to contacts and the like. Because my understanding is that a standard billing of this claim, we just rebill it, just send it in and they'll pay it. Typically doesn't work because of the age of the claim. They need somebody specific to contact and or someone specific to fax or email the claim to sort of override the age of the claim. And I think Mr. McLean might have some of that information. I did give him my email and I expect if he emails me, I can forward that to my client. Perhaps we can I can help facilitate getting the parties to get this billed and paid. I can't make a guarantee. I'm just trying to do the best I can, given what I have in front of me.
Okay, Mr. McLean, you willing to do that so that Mr. Cox can try to help you get this claim addressed with the VA?
Yes, Your Honor.
Okay, you have his email address?
Yes, Your Honor.
Okay, so I'm gonna grant your motion to set aside the default judgment. I'm gonna set this for a pretrial. We can use that pretrial date more as a status to make sure communication is ongoing and that any information that needed to be provided to Mr. Cox has been provided to Mr. Cox, okay?
Yes.
Give me 30 days. May 23rd. Does May 23rd at 1:30 work for you?
Yes.
That's good for the plaintiff, Your Honor.
Okay, so we'll set it for a pre-trial, May 23rd at 1:30. We'll send you another notice in the mail, Mr. McLean. Please put this date and time in your phone. Place a reminder a week prior to in your phone if necessary, so that you can make sure you're here on May 23rd at 1:30, okay?
Yes, Your Honor.
Okay, do you have any questions, sir? Mr.
No.
McLean, do you have any questions? Okay, any additional matters for the record on this, council?
No, Your Honor.
Okay, you're all set, sir.
Hello, excuse me, Your Honor.
Yes.
It was one more thing about the garnishment.
Well, I've set aside the judgment, so the judgment, the garnishment is gonna be essentially a moot point. I'm gonna strike the garnishment because there's no judgment for them to garnish on,
Okay.
Yeah,
okay?
my office will try to do a, I guess technically this would be a release on the basis the judgment's been set aside. We've not received any monies. I was telling Mr. McQueen, I know monies have come out of his check. He gets paid weekly, but we've not received those. That doesn't mean they may not be in the mail on their way here. But if we haven't gotten them by now, the objections that he filed effectively tell the employer to withhold those monies to await the order of this court. So I'm hopeful that the order of this court will then release the monies back to Mr. McLean.
Okay, sounds good. Okay. I do have your order here. I can place here to have the monies, any monies that was withheld and set aside released to you. Okay, Mr. McLean?
Yes, Your Honor.
You have any other questions?
No, Your Honor.
Okay. Any additional matters for you, counsel?
I'm sorry?
Any additional matters for you?
Not in this case, no, Judge.
Okay, we'll see you both May 23rd at 1:30.
Thank you.
All right, have a good day.
Same to you. Okay. Thank you. We're on the record in the matter of Edward Sparrow Hospital. Versus Michael Anthony McCohen. File number is 22-00312 GCE. Counsel appearance, please.
Good afternoon again, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff P59146.
Okay, and Ms. McCohen, do you have an attorney representing you at all?
No, I don't.
Okay, today was the date that was set for a pretrial on a civil matter. We do have an email, sir, that was placed in the file. States here that you would like to appeal the summons that was made against you. The summons was issued on February 24, 2022, expiring on May 26, 2022. You're appealing the summons due to you having health insurance, and your insurance should have covered the charges. You've met privately already with Mr. Cox, correct?
Correct.
Okay. And you provided him information regarding your insurance?
Yes, I did. We spoke briefly about my insurance, and he let me be aware of the dates that Sparrow Hospital was charging me, and it might have been a mishap with my insurance. So I informed him that I was going to. He emailed me over the dates and the actual events of the visits to Sparrow, and I'm going to call my insurance company and make sure that I had insurance during those dates.
Okay, I have here dates of service for March 17, 2018, September 20 of 2018, and then September 29th, 2018. Is that the date you received?
I didn't go over. I didn't look at my email yet, but those.
Okay. So it sounds like, Mr. Cox, do you all need additional time to see if he can get that worked out?
Yeah, I think so, Your Honor. We had tried to mail these to him in March, but he said he didn't get them. So he gave me an email address, or we used the email address from his answer. I've emailed him the itemized statements. On 2 of the 3 bills, it looks like perhaps insurance didn't pay anything. Not coincidentally, I suppose, the smallest bill is the one it paid upon, and the 2 larger bills are the ones that it didn't. It appears that there are just patient discounts provided, which I believe are uninsured discounts, whereas the first one shows insurance payments, and it reduced down to a patient deductible. But yes, Your Honor, I think if we had some more time, that'd be helpful. He now has the itemized statements. Going to take him to his carrier to get started, see where that takes us, and if he has got additional insurance information to provide me, or he can find out more from his carrier, we'll probably understand better what happened with regards to the third party here.
We'll do May 23rd at 1:30 for a new pretrial date.
That works for the plaintiff, obviously. No,
Okay,
that's
that works for you as well, Mr. McCoolin?
Yes, Your Honor.
And I would
Okay, so that can be
encourage,
resolved. I'm
Gotta
sorry, I
encourage-
couldn't hear you.
I would just encourage the defendant to keep me apprised of any contact he has with his carrier, good or bad. And any information that he has to provide, to email that to me, given the email address that I provided him or emailed him. So that, and not to keep it, I guess, a secret till we come back. The more information I can get, the sooner, the better, because then I can act upon it before we're forced to come back before Your Honor.
Okay, do you have any questions, Mr. McCoolin?
No, Your Honor.
Okay, then you're all set. Thank you, Mr. Cox.
Very good. Thank you, Your Honor. Have a good day.
Same to you.
Bye-bye now.
Thank you, Mr. Chisholm.
Good afternoon, Your Honor. How are you doing?
I'm good. How are you?
Good, thank you, Judge.
Okay, you were here for a pretrial against Andrea Buff. She's not appeared. So default judgment can be entered. You can submit your request to Judge Simmons Courtroom at lansingmi.gov, okay?
I'm writing that down. Judge, I think I have that, but Courtroom
Judge
at
Simmons Courtroom?
lansingmi.gov.
Yes, sir.
Thank you very much, Your Honor. Hope you have a wonderful day.
Thank you. Same to you.
Thanks, Judge.